Hello, this is Laws 11046, Law and the Environment, John Milburn, your course coordinator. It's week 2, and this week we've been discussing Chapter 2 in Bates, dealing with a number of issues, including the doctrine of separation of powers, native title, dealing with the issue of property rights, which encompasses the issue of common law versus legislation, an introduction to compensation in certain circumstances, and the way in which environmental policy is translated into law. So if you have any questions, please unmute your microphone and simply ask or use the chat facility as we have down the bottom. A couple of preliminary comments. The first is that I would like to see every student attempt an answer to the questions which, for the most part, will be on the Moodle site week by week. I know a few of you have answered question 1 and a few have answered question 2, but I would like to see everyone provide their commentary and their answer. Now, don't be embarrassed. There's no answer as a silly answer. It's all a matter of your discussion. And remember, of course, that I'm really interested in the way in which you mount an argument and not necessarily interested in whether that particular argument is true or not. Now, so that's on the Moodle site, and please upload your answers as you think of them, and I'd really appreciate that. What I propose to do is discuss in open forum and then provide some notes on Moodle and UCrew, my thoughts in relation to those particular questions, and I'll provide some commentary in relation to questions 1 and 2 at the same time. Now, the thing about those is that they deal with the issue of common law versus legislation, and they deal with the separation of powers. That's going to be a factor to be mindful of throughout the entire course, because what you need to consider is who actually is wielding this power, who's making the decision, and in what capacity and to what degree are they lawfully entitled to do that. So that's just to foreshadow what we might be doing next week, dealing with questions, my response to questions 1 and 2, which are uploaded in Moodle. So it's not examinable, but I would certainly appreciate everyone contributing. Now, the next thing is that I would like to briefly touch upon the first of the assignments, and in particular question 1, which deals with the Predejohn case. So if you haven't looked at that case, I'd urge you to do that now. Start thinking about it, try and get a feel for it. It probably will take more than one reading. Remember that my general strategy, which I'm promoting to you, is have an overall gloss over type reading first up. Try to get a feel for it. Don't be too stressed if it doesn't click immediately, because the Predejohn case has some really interesting topics in it. Bear in mind also, and it might be a few weeks down the track, that there is a Zoom session, which was from last year, involving myself and more particularly Rod Litzter QC. Rod was one of the barristers who was directly involved in that case. So if you want to hear from the horse's mouth, as it were, how that case panned out, which might be useful for the assignment, have a look at Rod's, the video that I prepared in conjunction with Rod. So very briefly, I won't talk too much about it, but I will give you some guidance in relation to the Predejohn case. So it was, of course, a decision of the Planning and Environment Court, which was in Queensland, and the Planning and Environment Court is at the same level and constituted by the District Court, so District Court judges. So it's at that level. And you'll recall, I think previously we said, when we're referring to a judge in the District Court, the reference is judge. When we're talking about a judge in the Supreme Court, the appropriate reference is justice. So in this case, it was heard by Judge Everson, which indicates he's a District Court judge, as opposed to, in another case, it might refer to justice, for example, Justice Wilson, who is a Supreme Court judge. All right, so in the Planning and Environment Court, this was heard in Cairns in February and March of 2012, and in that case, the applicant Predejohn was appealing against a decision by the council refusing his development application in relation to some land that he had bought at a place called Taylor Point, which is an area north of Cairns. I haven't been there. I'm told by people that it's very nice, and we may even have some students who actually know that location. So that's the scene. We have Predejohn appealing against a decision that he didn't like, which was imposed upon him by the council following his development application. Now, this case was important for a number of reasons, but clearly it was an environmentally significant piece of legislation, vegetation rather, which was on the particular site in question. So there was some environmental sensitivity to the site, and I guess that's what gave it the impetus to be in the Planning and Environment Court. When you read the case, if you haven't already done so, you'll see that the applicant made an application to council back in 2010, and he, that is Predajon, applied for 2 permits. One was for what's called a material change of use, and the other one was for a reconfiguration of a lot. And what he had in mind was to redevelop Lot 10, which is described in the case, into 30 residential lots. He was going to include a public park, and it was going to be a comprehensive development, if you like. So the application which he made, the plan which he developed in conjunction, no doubt, with consultants, had some ramifications in relation to the environment. He argued that he had taken those ramifications into account in preparing and submitting his plan. He included a covenant, for example, to prevent clearing in certain areas. He proposed a covenant which would bind buyers to the effect that houses had to be limited in the size. 2 parcels were dedicated for public reserves, etc. So you'll see there's some commentary about the way in which Predajon originally approached this case, this original development, in terms of what he wanted to have as an end result. So he then argued that if one considers what the land was like in its current condition, with the consequent problems associated with weeds and erosion and stormwater sediment runoff, dumping of rubbish, etc., that developing the land would actually lead to a better outcome and better protection to the area than if it was left in its natural state. So that was the position of the applicant, Predajon. The council, of course, were confined or constrained, if you like, by legislation and the planning schemes. And you'll get a feel for the planning schemes that are relevant in this case, and there's reference to that. There is an interesting legal issue in this case, and that is that even though the case was decided, very recently, the law was determined in accordance with aspects of the Integrated Planning Act, which is the law back in 1997, as well as some other planning schemes, the balance of the City of Cairns scheme back in 96. And the reason is that they made up the laws that were relevant at the time of the development application in 2010. Now, by the time the appeal came to the court, the Integrated Planning Act had been superseded by what is the current law, the Sustainable Planning Act of 2009, and it was in force. But there is a section in the Act, that is the Sustainable Planning Act, that says that matters such as the Predajon matter must be dealt with in accordance with the terms of the law as it was previously and not in the current Act. So you'll have a look at section 819 of the Sustainable Planning Act, and that will give you a guide in that regard. All right, so I won't talk much more, lest I give the whole thing away, but there are a couple of issues here that were relevant to the case. The first is that the development application would have to be refused if it conflicted with a relevant strategic plan or a development control plan. That's one question. And the second is, were the planning grounds insufficient to warrant approval? So if the planning grounds were insufficient to warrant approval, can the matter still proceed? Anyway, that's a convoluted way of saying what I wanted to say, but I'll leave. The purpose of tonight's was just to get you going, get you started on that case, overcome the panic factor that you will invariably face when you read the case thinking this is overwhelming, I can't do this. Try to get over that, get over it quickly, try and get to the heart of the matter. And remember, of course, that in this assignment, as in all assignments through the university, at least in my experience, the first 50% is so much easier to get than the second 50%. It kind of gets progressively harder for each 10% as you go along. So, for goodness sake, Don't be daunted by it. Just get in, roll up the sleeves, make yourself a coffee or a tea or whatever, and get into it. I'd really like to see some discussions on UCREW about this assignment. In fact, I'd like to see a lot more discussion on UCREW. It's all very quiet, too quiet for my liking. I like the courses that I'm coordinating to be very busy places. All right, now nobody's asking any questions on the chat facility. Does anyone want to come in and ask a question about the Predajon case or the assignment or the reading for week 2 or the assessments, sorry, not the assessments, the questions that I ask on Moodle to be answered? No questions or comments?
I've watched through the video with the QC and made about 6 pages of notes in preparation for assignment 1. So yeah, I think that certainly helped kill the panic factor a bit. Just watching that interview with him. So.
Okay, thank you very much, Michelle. Really appreciate that feedback. And you will have that panic factor, and I think that's really good to acknowledge that that is the case, which will occur from time to time. It just happens. And good to get through that and break through that barrier. Don't leave it to the last minute. I gave the warning during the week that I'm not very nice when it comes to assignment assessment requests or extension requests. I'm sorry. All right, now let's talk a question here. Can we explain common law a bit more? I think that's a really good question, and I think we need to discuss that in a bit more depth. So in anticipating that might be the case, I did have on my screen, at least at one stage, some notes that I wanted to run through. And conveniently, it looks like I've got rid of those. So I'll just call them up again on my screen. And while we're doing that, just by way of reminder, the common law is one part of the way in which law is made. The other is statutes. Does anyone want to, given that I'm keen to try and make this partly a discussion session, does anyone want to tell me, just briefly, the difference between legislation and common law?
Well, from what we've read so far, common law is about individual rights and has come to us through the English justice system, whereas legislation is about protecting social or community interests.
Yes. Thank you, Michelle. That's great. Any other comments? All right. So, in essence, legislation is introduced through Parliament. It takes the form of acts or legislation. In itself, it overrides potentially common law. Common law is the law that's made by judges progressively, and where you have a conflict, the legislation will prevail. And the whole rationale behind these two distinctions is this, that if Parliament was called upon to be the only place where laws were made, the laws would be huge, trying to cater for every possible circumstance. But invariably there will be either a disagreement or a requirement to interpret the legislation one way or the other, and that's where the courts come in. When the courts make a decision, that decision potentially forms part of the common law, in that it may be regarded as binding or at least persuasive on other courts that might follow after the event. It will be regarded as binding if it's on point and it's a superior court. So if, for example, the High Court makes a decision in relation to a question which touches upon environmental law, then that decision of the High Court will be binding on all courts in Australia, Supreme Courts, etc., which may deal with that same issue. So lawyers would then argue that in accordance with the terms of the decision in the High Court, then this is the way, for example, the Planning and Environment Court should deal with the matter. Just in the common law, just watch, there is a distinction between that which is goes to the heart of the decision, and commentary, which is indirect and doesn't necessarily go to the heart of the decision. By that I mean, if you have a case and it's exactly on point, and the reason that the court in the first instance decided the case was because of that point, then that particular point, ratio decidendi, thank you, Michelle, will be that will need to be followed by other courts, as opposed to perhaps a commentary or an incidental, if you like, comment made by courts. That's not necessarily going to be binding, and that's what we call obiter dicta or dictum. All right, so that's common law. Now, I will just confuse things a little by saying there's a difference between common law and legislation, which is parliamentary laws versus judge-made laws. And there is another distinction, and this is a historical distinction, between what's called the common law and equity. Look, it goes back to medieval England, and I won't go into a whole history lesson on laws, but essentially it comes down to this. In medieval times in England, the common law, as it was called, was really quite harsh, and we called it black letter law. You're either yes or no, depending on exactly what's written. There's no grey areas. It was all black or white. But what that led to was many decisions that were technically right, but really unfair. And as a result of that, for better or worse, a rival court system was established, which was essentially monitored by the king or queen, and it became the court of equity or chancery. But it was based on equity, fairness. And so what would happen is that we had these two different court systems running for hundreds and hundreds of years. Eventually they merged with the Judicature Act in Australia, where they were merged. So now we have common law and equity essentially rolled up as part of the overall common law. So we still call it the common law, but it has the original common law, which is black letter, and has the equity. Now, a bit of a giveaway for what's an equitable thing and what's a common law thing in that technical sense is this, probably the remedies that you might seek. I'll give you an example. Let's say someone purchases a block of land. That block of land is particularly unique and the seller refuses to settle for no good reason. The buyer could institute proceedings to say, I have lost the value of this property. And what you do is you say, well, look, here's how much I bought it for, and here's how much it's worth, and I want to sue for the difference. Now, the fact is that there may not be any difference in reality. A valuer might say it's valued at what you were going to pay for it. You haven't had to pay for it, so you've suffered no loss. But in equity, they would say, look, that's not fair. You really are entitled to that block of land. You have to pay for it, so we will force the seller to sell it to you, and that would be an order called specific performance. So that's an example of an equitable remedy which is based on fairness. Now, having thoroughly confused you, are there any questions in relation to those distinctions? So you'll see some commentary from time to time where there might be talk about declarations, injunctions, restitution, specific performance. These are all equitable remedies as opposed to common law remedies such as damages, payment of money. Okay, so that is in a nutshell my very brief overview of common law versus legislation and common law versus equity, now essentially wrapped up. I will just mention one other thing. Not every court is vested with equitable jurisdiction. So if you went to the magistrate's court and you wanted an order from the magistrate by way of specific performance, that is an order that the magistrate makes forcing someone to do something, which is an equitable remedy, the magistrate will say, I have no jurisdiction to grant equitable relief. So in that instance, you would have to go to a different jurisdiction. The District Court and Supreme Court and QCAT have equitable jurisdiction. The Magistrates Court does not. Not every court is able to provide every remedy that you want. Sometimes it's a matter of selecting the court that's most appropriate or the court that can only deal with your matter. Okay, nothing on the chat line. I must have explained that so well. Nobody is expressing any concern. We're all fine. Okay. In chapter 2, there was also some discussions of the native title. Now, remember, of course, that native title was established through the High Court acting in what is called judicial activism to essentially create some law that didn't exist before. That's a little different to the common law. The common law is created when the courts interpret or define something that might be in existence through legislation already. But judicial activism is where the courts just create something out of nothing. And Mabo's decision, the Mabo decision in 1992, is probably, to my mind, the most outstanding example of judicial activism. So that is where, from that, the Native Title Act was passed to essentially ratify the decision that was made in Mabo. Part of the reason why Australia was regarded as settled rather than conquered is that the Aboriginal Indigenous people did not have the same concept of property that Western society had of property. And this concept that people could own individual parcels of land really didn't exist in customary law. And the other reason is that customary law with Aboriginal people and Torres Strait Islanders is that historically there were a few issues that were quite different. Sometimes customary law was kept secret. Sometimes it was passed on verbally. It wasn't written, and that was, if you like, the excuse why Western civilization saw fit to essentially ignore it until such time as Mabo and the Native Title Act. Now, that concept has been advanced and extended through a few decisions. For example, the Wik people and State of Queensland. That sparked some controversy when a court decided that the grant of a pastoral lease did not necessarily extinguish native title. All right, we've talked about the concept of terra nullius and the fact that Australia was declared to be empty land, and that's why there was no treaty. That's why the Indigenous legal system was ignored, and that's what led to Mabo and native title. And just remember, of course, that there is the native title, the National Native Title Tribunal, which deals with certain issues in that regard. Okay, now, are there no questions? All right, so what we're going to do during the next week is invite you to get cracking on Preterjon. Make sure you at least read it. Make sure that you read ahead by one chapter. Have a look at the videos that I post, and if you want, you can follow along my commentary, if you like, of the chapter, which I'll put on Zoom. I'll try not to make it too long, try not to make it more than 20 minutes. And I do want you to answer the questions that I post on Moodle from week to week. Some of you are already doing that, so I'm probably preaching to the converted if you're watching this presentation. And finally, I want you to get very active on UCrew. Let's really ramp it up because it's too quiet. Okay. All right. Are there any questions before I wrap up for tonight? Any comments? Anything you want to discuss? Looks like a no. Okay. Well, look, let's speak during the week through UCrew. Thank you very much for participating tonight. Really appreciate it. And if there are any questions, Moodle or UCrew, that'd be great. All right. I'll stop recording now.